So I'm going to introduce to see that you are not making this up, but the child really need those to pay for the school fees. The child really need transport. The child really needs all those things that needs to be done for the child to survive on day-to-day basis. Then, after going through those expenses, and then we have agreed with the respondent to say, okay, fine, these are the real expenses of the child. Then that is where we come to, people usually talk about paying 50-50 based on, but this 50-50, when we say 50-50, it does not stop there. It's 50-50 pro rata. So it's 50% for according to the means of your income. So after having gone through the list of expenses and coming up with the total amount, then we are going to look into what is the 50% that the respondent has to pay, and what is the 50% that the applicant has to pay based on their income. So if you are earning 10 rands and the other one is earning 5 rands, then the expenses of the child maybe, I'm not saying that will be the case, but you might pay 5 rand and the other one will pay 2.50 because of the means of income after the calculations. Then after doing that, then we'll go again, and when we go through the expenses of the children, we'll also be going through the expenses of the applicant. Then from there, we'll go into the expenses of the respondent. Then we are going to look into his means of income, how much does he make on monthly basis, and then go into, zoom again into the expenses. What does he do after receiving his income? Okay, let's say, then we are going to say, what do you do with this 5 rands? What do you do with this 10 rand? Then go through his list of expenses. Now the applicant also, you will be given an opportunity to question some of the expenses of the respondent, to agree with those that you agree with, and to disagree with those that you don't agree with. And also we'll look into, these are the expenses of the respondent. And maybe sometimes, and most of the time, after going through the expenses of the respondent, we find that after the salary does not allow for the maintenance of the child. So if the respondent comes and say, I'm paying for a house, what we will need, we'll need the original contract, because the payslip, the bank statement will show that the respondent is paying for a 10,000 rand a month for the house, but maybe the contract, in the contract it's saying he must pay 5,000 rand. So we will have to look into that contract and see what the contract says. And if the contract says he must pay 5,000 rand and he says, you know what, because I want to finish paying this bond within 5 years or within 10 years, then I want to double the amount so that I can finish paying the bond earlier. Then we will look into that to say, but you have got this 5,000 rands that you can use for maintenance, because the contract doesn't say you must pay 10,000 rand per month. Same goes to the car. If he has got a car, he will have to bring the proof and all the other loans that he is having. Then that is the way that we will find maintenance for the children at the end of the day. Then at the end of the day, then we'll say, how much can the respondent afford under the circumstances? Because we must remember that each and every case is determined by its own facts. So at the end of the day, we are going to say, how much can the respondent really afford? And when we find that the respondent, this is the amount that the respondent can afford, then we will look into that amount and we will now negotiate and see if we can come to an amicable solution. But unfortunately, as the maintenance officer, I am not allowed to force you into any type of an agreement. If you are not in agreement, unfortunately, then I'll have to take the matter to court for the court to make, then in court, then we are going to lead evidence and the court is going to make a decision. And the decision of the court is the decision of the court. You don't even need to sign for it. That will be the decision of the court, and that is what, at the end of the day, the respondent will have to contribute towards the maintenance of the child. Uh, Then the other one that we have is that you find that somebody says, you know what, I've made an application for maintenance. My matter has been on the roll for about 6 months, but I am not seeing any progress, or my matter is not being finalized. Believe you me, the department wants to finalize your matters as early as in yesterday. We are striving to do that, and we are trying by all means to make sure that your cases are finalized within the required time. But unfortunately, there are those things that hinders us from finalizing these cases as quickly as possible. And one of those things is wherein you find that earlier on I was talking about the respondent, you having the best, the physical address of the respondent, either his work address or his physical address where he stays on daily basis. But it happens sometimes that the applicant does not know the present address of the respondent. Then we send the subpoena or the directive to this location only to find that they are saying the respondent is no longer staying there. So we don't know the last known address. That is not the last known address of the respondent. The respondent has moved on and is no longer staying there. Then unfortunately, then our maintenance investigators have to go deep and go and search as to where the respondent is at that particular time to enable us to now send those subpoenas to the new address of the respondent. And that is some of the things that might make us not to finalize our cases as quickly as we would like to, because we all know that when we talk about maintenance, we are talking about vulnerable groups, and we are talking about the best interest of the child, which need to be upheld at all the time. But unfortunately, that is some of the things that makes us not to finalize these cases as quickly as possible and as quickly as we would like to. And the other thing is that when we have to follow the procedure when doing maintenance, and some of the procedures that we need to follow is for me to ask you when you arrive on your first day to say, will you need legal representation? And unfortunately, I have to ask this question. And if any of you says, then I will need legal representation, then I'll have to I don't have to proceed with the matter, then I'll have to postpone the matter for the legal representative. And sometimes it happens that when the legal representative arrives, I mean, when we give him, you give him the date, him or her the date, you'll find that the legal representative is not available on that particular day, then we have to postpone again. And that also hinders us to finalize the cases as quickly as possible. The other one is wherein you find that the respondent now says, you know what, I am not the father of these children. Unfortunately, when on the first day when you come to court, I have to ask this question. Sir, according to the applicant, you have 2 kids with the applicant, and then are you the father of these kids? And then the respondent at some times will say, yes, I agree that I had a relationship with this lady, but we do not have a child together. Those children are not my children. And now, unfortunately, the proceedings have to hold, and we have to take the matter to court for the magistrate for a financial inquiry and for the magistrate to assist us to arrive, for the magistrate to decide as to who is going to pay this maintenance, who is going to pay for, not maintenance, but who is going to pay for this paternity test. The court can say the respondent must pay for paternity test. The court can say the applicant must pay for the paternity test because it's in the better finances. Or the court can say, both of you, I can see that you are not in a position to pay for the paternity test. Let the state pay for the paternity test. That is also possible. That can be done. Then we'll have, if the court says somebody must pay, maybe the respondent or the applicant must pay for the paternity test, then we'll have to postpone the matter for the payment of the paternity test and for the paternity test to be carried out so that we can decide as to who is going, whether the man or is the father of the children. And if we find that the respondent is the father, then we will then proceed with our inquiry so that we can finalize our matter. But if we find that the respondent is not the father of the children, then the matter will close our file, and that will be the end of the case. That is some of the things that are hindering us to finalize the matters. And sometimes, unfortunately, our respondents, when they've been warned by court or they receive our subpoenas, they ignore those subpoenas and they don't come to court. And if you decide not to come to court, unfortunately, we will end up making what we call a default judgment. If you were properly served and you do not come to court, we will end up making a default judgment against you. And believe me, as a respondent, you will not like it, because we will be deciding on your finances in your absence to say, this is what you are going to give to your kids. Whereas maybe if you were here, you would be talking for yourself and you will be showing the court that this is not possible. It will not be easy for me to do those things, to pay all this amount, or maybe I do not agree with the expenses 1, 2, 3, and that will be able, you will be able to be assisted. But unfortunately, if you ignore our call to come to court, we'll have no other option but to make sure that we take that decision on your behalf in your absence. And at the end of the day, you might find yourself, your money being deducted from your salary. So if we call you to court as the respondent, we are not fighting you. We are saying to you, there is an allegation that there are these kids who are your children, and we would like you to come and for us to talk about the upbringing of these children. Nobody's fighting. You are not even an accused person. We are saying, come, let's talk and see how best can we raise these children. So please, out there, when we call you to court, please heed our call and come to court. So I've been talking in English, unfortunately. Let me just summarize what I said in Spade. Go na le motho o dutse gae o re ke nyaka go dira kgopelo ya support mara ke tsebe gore ke dire jwang. Go sa tsebe gore o dire jwang, emelela o ye khoto ya kgauswi le wena. Ge o fitlha o ba botse gore ke nyaka office ya support. Go fitlha ko officing ya support o ba kgopela gore o ye o tshwere dipampiri tse di latelang. O tshwere marriage certificate e le gore e gona, o ye o tshwere birth certificate tša bana, o ye o tshwere ID copy ya gago, o ye o tshwere proof of res ya gago, o bontšhe gore ya gore o dula kae, botlhatse ba gore o dula kae, o ye o tshwere gape le dinyakwa tša bana, o tshwere le salary advice ge le gore wa šoma, and then o retle gape o kgone go tlo re botsa gore pape bana ba o kae, o dula ko kae, and or o bereka ko o šoma kae. And ge o sa di kgone go tla le dilo tse ka moka tse ke šetseng ke di badile, especially mo e leng gore o kry-e le gore wena a o tsebe gore ngwana papa go bana o ko kae ka nako eo. Seo se se ka go thibela o tla khoto, o fitlhe khoto o bolele gore nna batho ba modimo, nna ke na le ngwana, ke na le bana, papa bona a ke tsebe gore o ko kae, o sa la tsamaya. And then mara at least o na le phone number ya gage, tla le phone number ya gage, and then o re botse le gore la mafelelo na a dula kae, la mafelelo na a bereka kae. Di-maintenance investigator tša rena ba tlo le thuša gore re kgone go mo tracer, re kgone go mo kry-a. And re kgopela gore list ya lena ya di-expenses ke buletše in depth ka yona, re tshwanetse re make sure ya gore list ya rena ya di-expense dinyakwa tsela tša bana ke la re bolelang ka tsona tsela e leng gore nako nngwe re na le go kwa okare le go fila o kare mara court o kare a ya ntirela justice mo ka gore nna ne ke gopetse 10,000 mara gona ba mphile 3,000 rand then ntho o tshwanetseng o e lebelele ke gore mara this re tlo lebelela gore a na di reng dinyakwa tša bana ba gago ka se se tee go fitlhelela mafelelong and then ra lebelela gore and respondent le yena o tlo fiwa nako ya gore a go botšiše dipotšišo a dumelelane le di-expenses tša gago or a se ka dumelelana le tsona and then wa sa dumellaneng le tsona tshwantse a fe lebaka la gore wa ya sa dumellaneng le tsona and mo a dumellanang le tsona then we are fine then at the end of the day re tlo dia recalculation then re fetsa go dira recalculation ra re okay fine ke di-expense tša bana tše then go na le ntho e la e bolelwang kudu-kudu ba re ke 50-50 50-50 re lebelela 50-50 go ya ka letseno la lena ba babedi so if o mongwe a gola 5 rand o mongwe a gola 10 rand le ka se patele tšhelete ya go lekana it means wa golang 10 rand o tlo tshwana go patela ntšhinyana ka gore o gola tšhelete ntšhi so ba bangwe ba lla ba re mara why di-case tša rena di sa fele ka pela ko kgotho re ile ko kgotho di-case tša rena di tšea nako di-case tša rena di fele ka pele go na le dilo tše dintšhi tše e leng gore re tshwanetse re di lebelele re le lefapha re nyaka go fetša di-case tša lena ka nako e nnyane ka gore re lebeletse gore bana ba sokola and bana ba tshwanetse ba kry dišo but unfortunately nako nngwe ga go be moroba go di fetša ka pela ka mokgwa o tshwanetse re di fetse ka pela ka ona because go na le dilo tše dintšhi tše tshwanetse re di lebelele go tshwana le gore pape ngwana a re nna a se nna pape ngwana o tshwanetse re lebelele re nyakišiše gore ka nnete ke pape ngwana na pele re ka re a support nako nngwe o kry-a re sa mo kry-e pape ngwana re tshwanetse re monyake di-maintenance investigator tša rena di monyake go fitlhelela ba mo hwetša and e nngwe o kry-a le gore o rile ke nyaka moemedi jale moemedi nako nngwe o kry-a le gore re a postponela moemedi and dilo tšeo ke tsona tše e leng gore di a re tshwarelela ka nako tše ntši ke a leboga.
Thank you, Advocate Palane. Let's hear from the presiding officer, Ms. Busiswe Nkosi. How do they enforce the maintenance orders in their court? Over to you, madam.
Thank you very much, Program Director. Good morning to our viewers. Now, what's important is what happens after a court has granted an order. The ideal situation, we expect that the person against whom the order has been granted will pay as ordered by the court. That's an ideal situation. But unfortunately, we find ourselves in a position whereby other people, they don't take the court order seriously. They will either not pay or pay part of the order, or they just stay away and don't pay. Now, the question is, if that happens, who suffers? The child, because in most instances, maintenance is for the children. Yes, it can be for spousal maintenance or for another person, but mostly are the children. Now, the whole exercise that has been explained by the colleagues, it then becomes a futile exercise because now the complainant will be frustrated. I'm sitting with an order. The respondent is not paying. Now, what should happen under those circumstances? The Maintenance Act, which governs maintenance matters in the Republic of South Africa, gives us remedies of, I'll say, forcing the person against whom the order has been made to pay, because if he does not pay voluntarily, then now he must be forced to take his obligation seriously. So now, in terms of the order, there are two ways that the enforcement of the maintenance order can be done in terms of the Act. We've got the criminal way. We also have the civil way. Now, when must then the complainant come and say, I'm having this order the respondent is not complying with? In terms of the Act, if after 10 days the order was not complied with, then the complainant can come to court and ask for enforcement. That is 10 days after the date on which the respondent was supposed to pay. Let's make it for an example that, let's say, he's supposed to pay on the 30th of the month. And then now, by the 11th, he hasn't paid. Then that is now the 10 days has lapsed. I know people will tell you that they were told to come only after 6 months. That's not what the Act says. The Act says it should be 10 days after the date on which the order or the amount was due. So it's very much important for the complainant to ensure that enforcement are done as early as possible. Don't wait for the area amount to accumulate and be more, because that might cause problems when now it comes for enforcement. Now, let's look at the criminal remedy. Indeed, if you are being owed, what you'll do, you'll go now to the maintenance court with your bank statement for that period that the respondent was supposed to pay. When you arrive there, you will inform the clerk of the court the purpose for your visit, that I'm here for enforcement. The respondent is not paying as ordered by the court. Remember, I said it can be partially, it can be full. When I'm talking about partial, let's say he has been ordered to pay 500 Rand and he only pays 250 Rand. That's partial fulfillment of the court order. Or if he's ordered to pay an amount of 500 Rand plus pay school fees on a monthly basis or buy clothing at a certain period, and he does not do that, that is partial fulfillment of the order. Now, then you must have the bank statement. Why the bank statement? That is proof to say that the money that was supposed to be deposited in that bank account that the respondent was ordered to pay to, he did not pay. So now, I said we start with the criminal enforcement. If you go the criminal enforcement, what will happen will that summons will be issued against the respondent, calling him to come to court for the enforcement of the order. On that day, the matter will go to court, where he will be asked to plead. It's either he's going to plead guilty or not guilty, and then it will proceed. Another thing which is important, Kolia, is to ensure that monies are paid where they're supposed to be paid. Because now you'll have the dispute whereby the other say, no, but I gave the money direct to the complainant without paying it to the designated bank account. That will now cause problems because it will be your word against his word or vice versa. So people are encouraged to make sure that at all times the money is paid on the account that was ordered by the court. Now, let's say at the end of the day, after the trial, the accused person is convicted for failure to pay maintenance. In terms of the Act, it says on conviction, the person can be sentenced to imprisonment, which can go up to 3 years, or to a fine. Now here, the presiding officer has got now a discretion as to which sentence to impose. But in most instances, because one of the purpose of the Maintenance Act is to collect money, maintenance money for the children. So now if you've got this person who is employed and he didn't pay his maintenance, now he is taken to prison, it defeats the purpose. So in most instances, not to say that I'm being prescriptive to what the presiding officer will do, but in most instances it will be a suspended sentence with condition that he complies with the order and that he pays the area amount that he's owing. Now, what happens if he raises a defense? Because the Act allows him to raise a defense. Defense of lack of means. Lack of means, it means that at that particular time when I was expected to pay my maintenance, I did not have the money. So if that can be proven to court that he was unemployed, whatever reason that made him to be out of money and it's acceptable to the court, the accused person will be found not guilty. It's also important now to the respondents, with the people against whom orders are made, that if they encounter or experience financial problems that makes them not to comply with their obligation, that they come to court and explain their situation so that an application can be made for the suspension of the maintenance order during that period. Or else, if the court is not sure as to whether the respondent failed to pay because of his own doing or his own misconduct, there is what is referred to as a conversion. What will happen there now, the matter will be referred back to an inquiry, whereby now they will go back, look at his financial situation, and then a decision will be made whether he will proceed to pay the maintenance or not. That is now the criminal part. But what's now important also to note is that if you are convicted, you've got now a criminal record as a respondent. And the Act also allows that if a person is convicted, that person can be blacklisted. Meaning now you can't have credit because you are failing to meet your obligations. So now, most of the times people think that a maintenance order, it's nothing. I can just stay away and not pay it. But now you run the risk of having a criminal record just because you ran away or you tried to run away from your responsibility and not pay maintenance as ordered by the court. Now, moving on to the civil remedies. The civil remedies are also governed by the Maintenance Act, not the Civil Procedure Act, because now that's the mistake, or that's now the problem that we encounter at some point. Now you find people want to invoke the provisions of the Civil Procedure Act, whereas we are dealing with a maintenance matter. And there are procedures that are in the Act, in the Maintenance Act, which needs to be followed. Now, same applies here. You must have your bank statement depicting the period on which the respondent was supposed to pay. And when you approach the court, then you see, I'm being owed this amount and want to invoke the civil remedy in enforcing the maintenance order. We've got 3 ways of doing it. The first one is the emolument attachment orders. Now, what is emolument attachment orders here? Some will call it a garnishee order. It's when now you go to the court will make an order against the salary of the respondent. That is now the employer will be asked to deduct the maintenance money before the respondent gets his or her salary. So now a third person is brought into the picture to assist because the respondent is failing to take his obligation seriously. Now, there is a form, a prescribed form in terms of the maintenance regulations that needs to be filled. You'll be given that form to fill it. It will ask the amount that is being owed. And then you also have to make a statement under oath explaining that the respondent was expected to pay 6,000 Rand on the 30th of January. He did not pay. Now it's March. For the past 2 months, he failed to make the third payment. He's now in areas of 10,000 Rand. Therefore, you request that an emolument attachment order be made on his salary. Now, this one, it's in my view, it's a better option. But if a person is not formally employed, it cannot work. It works for those who are formally employed, especially those who are employed by the government, your teachers, nurses, police officers, and so on and so forth. Not to say that it doesn't also applies in the private sector. It does. As long as a person has got a regular salary, then an emolument attachment order can be made against his salary, whereby the employer will be asked to pay the monthly installment of 5,000 Rand, as well as deduct in installments the amount that is owed by the respondent until it is paid in full. Now, of note, a maintenance debt takes preference to any other debt that the respondent has. So the civil one of saying you cannot take more than a certain percentage does not apply. The maintenance debt, once it comes in, it takes preference to the other debts that the respondent has. Now, the second one is warrant of execution. Here you make an application to court to attach the respondent's movable property first, and then if that money that is realized from the movable property is not enough, then we go to the immovable property. Now, what is movable property? Movable property, we'll be talking to furniture, although there are other things that cannot be attached, but mostly it will be furniture, a car if it's fully paid. Now, the problem with the attachment of property is that sometimes you wouldn't know, you will thought this property belongs to the respondent, only to find that it belongs to a third person. He was using it, or it was borrowed to him. And another issue here, the sheriff is brought into play because the sheriff is the one who must now go and take inventory of the items that needs to be attached, remove them, store them, and also do the sales of the said items. And unfortunately, the sheriff does not work for the Department of Justice. He gets his cost from the person that gives him the job. That will be now the applicant. So, which means now after the sale of those items, he will first take what you owe him or her, and then you'll get the rest. So that you run the risk of either not getting anything after the sale of the properties of the respondent or getting part of the amount. But that is another remedy that is available to complainants that are being owed maintenance. The issue of selling immovable property, that will be now the house. The court will have to look at everything. If nothing else is there, then that will be a last resort. Because remember, in terms of the Constitution, a person needs to he has got a right to housing. And then the last one will be attachment of debts. Now, debts, we know debt is something that you owe another person. So now, if there is a third party that owes the respondent money, and that money is due or due in the future, then the court can make an order directing that person to pay now the money to the complainant instead of the respondent. It can be pension money, it can be dividends, it can be shares, whatever that can be realized as money can be attached and then paid over to the complainant or the person to whom maintenance is being owed. So now in all these three civil remedies, there is one form that is used, that is in terms of the regulations of the Maintenance Act, is called Form K, which will be given to the complainant to fill, and you choose if you want to invoke or use the emolument attachment route. You are gonna choose that one. If you're gonna want to use the execution warrant of execution route, you're gonna use that one, or else you can do the attachment of debts. Now, respondent also can, after the order has been granted, has got a right to approach the court and ask for it to be set aside. And the court will hear his application and then make a decision whether it stands or it does not stand. So those are the ways in which enforcement can be carried out. And one thing I need to stress is the fact that applicants or people who are owed maintenance, they need not stay away and say, he's not paying, so what? Because now the courts are there, they've got an obligation to ensure that the rights of children who are vulnerable, and also women who are also regarded as as part of the vulnerable groups, are protected. Because now if the other party does not take serious his obligation, then now the pressure is now left with the one who stays with the child, or with the one who's supposed now to get the money from the respondent. Thank you, Chair. I will pause here.
Thank you so much. At this stage, we'll call again Advocate Palane to tell us more about future maintenance. I hope today we'll learn a lot about maintenance and we'll be able to resolve the issues of maintenance. I would like to know, is this future maintenance for everyone or it's for some people? Over to you, Madam.
Thank you very much, Chair. My colleague has been talking about enforcing maintenance orders because I can assure you, you have nowhere to hide. Defaulters, you have nowhere to hide. After we have gone through all the processes, a court order has been made, the respondent decides not to comply with the court order. And after failing to comply with the court order, then we do what we call the emolument attachment order, maybe, or we attach the arrears in the forms that have already been alluded to by my colleague. And now the respondent decides that, you know what, I'm going to resign from my employment in order to frustrate the implementation of this court order that has been made to to deduct money from my salary. So I want to see what what they are going to eat. I'll see what to do, but I'm no longer going to work. Now I'm leaving my employment. I don't want to pay maintenance for my children. I can assure you that we are now coming after you again. If the respondent decides to do what I've indicated above, then please visit your maintenance office as early as possible, as quick as possible, because this is an agent application. You have to do it as quick as possible because we want to make sure that we get the money from the respondent. So at what stage do we say this particular case, this particular matter is a potential matter for future maintenance? Because as my colleague has asked as to whether we are just going to attach everybody's pension or not. So when do we say this particular case is a potential case of future maintenance? First of all, if we will look into whether the respondent is owing maintenance or not. So if the respondent is owing maintenance, then we know definitely that we are going after the respondent's pension to attach the future maintenance of the children, because the purpose of future maintenance is we go for future maintenance where we see that the future maintenance of the children is now at stake. If we leave this man with this money, we are definitely sure that the respondent is not going to comply with the court order and the children are going to suffer. They are going to suffer prejudice. So we make sure that we are going to attach that future maintenance. And another scenario is wherein you find that the respondent is not in arrears, because there are those respondents who knows that if you are owing maintenance, they are going to attach future maintenance. But if you are not owing, then they will not attach future maintenance in that case. So what they do before resigning, they will rush to court and pay everything that is owing, or pay everything that is being owed to the applicant, so that when we go and check, we find that the respondent is not owing. Are we going to leave it at that? And no, we are not going to leave it at that. We are going to zoom into the history of payment, the pattern of payment. How were you paying during the period of the order? Were you skipping some months and pay, or were you paying on time? Those are the things that we are going to zoom into and check as to whether this case is a potential case for future maintenance. If we found that you are that person who is not, we cannot rely on, that person who will pay as and when he pleases. The court said you must pay on or before the 7th of each and every month. Then you decide that this month I'm not going to pay, I'll pay after a month. Or maybe this month I've got my own responsibilities, I'll take care of my needs. Then next month I'll pay next month. Those are some of the things that will show us that once you get the money, you won't be consistent with taking care of these children. So we'll have to make sure that we attach the future maintenance so that the kids will not suffer prejudice. Then another one is, let's say the respondent is not owing maintenance, and the respondent never skipped maintenance. And the reason why, sometimes the reason why the respondent is not owing, the respondent is up to date and he never skipped, is because the money was being deducted from his salary. So there was no way that he can skip maintenance. But the applicant knows the respondent very well, and he knows that the respondent, the relationship of the respondent with money is very bad. It's not a good relationship. He does not have a good relationship with money. And he can prove that, you know what, the respondent once went to the bank, for example, and requested a loan of 500,000 rands, and he wanted to build a house with the loan. But once he received the money from the bank, then he took the money and gambled it away. Or the respondent took the money and entertained his friends with liquor up until the money was exhausted. And even today, he does not even have that house. In that case, we have got no option. If we have got that type of proof, then we don't have any option but to look into making an application for future maintenance. So the reason why I say you should come as early as possible is that we want to block the money so that the respondent does not access that money. And the other important thing that we should take into cognizance is that we are not going to paint every man with the same paint. We are not going to paint every respondent with the same paint and say, if the respondent, if he gets this money, then he will take the money and gamble it away. No, but we are going to look into the conduct of the respondent. The conduct of the respondent is very, very important when we deal with future maintenance. Even to the court, you also need to prove to the court that, but this particular case, this particular respondent that we are talking about here, Your Worship, cannot be trusted at all because of his behavior with money. So then the next one is when the respondent, when we find out that all these things, one of these things that I've indicated is there, then we are going to embark on making an application for future maintenance. So when we make an application for future maintenance, also the money does not go to the applicant, because the fact that we cannot trust the respondent with the money, we cannot also say we are trusting the applicant with the money of the children, because we want to make sure that the children do not suffer at the end of the day, because the applicant can also receive the money and spend the money on in a month or so, and then children are supposed to go to school. There is no one to take the children to school. So we also guard against that. So because the guardian fund is the upper guardian of all the children, what we are going to do is when we make that application, we are going to cite the guardian fund as a fund that will be holding the money on behalf of the respondent for the children. That money does not belong to the applicant. That money belongs to the respondent, so it will be in the name of the respondent at the guardian fund, but on behalf of the children. And the children will get what is due to them on monthly child, and that on respondent for the children. Then we will also inform the institution which is saving the money, whether it's the bank, whether it's the pension fund, whether it's the provident fund. We'll say to the institution, we have made an interim order. Please, in the meantime, do not pay the money over to the respondent up until such time the court makes a final order. So we are also going to say to respondent, we have realized that you were owing maintenance, or we have requested them the fund not to give you your money, so that we can finalize an application that we are having in our court of future maintenance, and serve all these documents to the respected recipient, being the guardian fund, the fund which is saving the money, and the respondent himself, to say. And we'll be saying to them, if any of you is having a problem with this court order, please come to court on this particular day, so that we can be able, the court can be able to make a final order. So usually these other institutions do not come to court. The only person who will be coming to court is the respondent because it's his money which is at stake here. So then the court will hear the matter, and after hearing the matter, the court will make a final order. It's either the court will say this interim order is made a final order, or the court may change the circumstances of the court order and say, no, this court order, now we are changing it. We are no longer attaching 50,000 rand or 100,000 rand. We are attaching 300,000 rand. It's possible for the court to say that. So once it is finalized now, we will serve it upon all this institution. Then we'll be saying to the to the fund which is having the money, if you cannot be able to hold this money on behalf of the respondent for the children and pay it over on monthly basis, please pay it into the guardian fund, for the guardian fund to hold the money on behalf of the child, this much money. Or so that the applicant can now go to the guardian fund and receive the money on monthly basis in terms of the court order. If the court order was saying that the respondent must pay 500 rand per month, then it must continue as 500 rands. So if the court order is going to, if the court order was saying pay 10,000 rand per month towards the maintenance of the child, the court order will remain so. So the applicant will continue receiving the 10,000 rands on monthly basis. So you can see with all these remedies which are available, that if the respondents do not want to take care of their kids, as the departments are taking it very serious, and they are making sure that the children are covered at all times. Once we see that the children are going to suffer prejudice, then we come in and make sure that we attach the money on behalf of the children. So I would say, let me try to summarize this in our mother tongue. Ka kgwedi tse pedi fela a e spenda ka jwala, a ija ka jwala, a ija ka maybe a gambola ka yona, a e fetša bana ba šala ba I mean e le gore na re lo ya ga ntlo mafelelong a se ya ge ntlo. So re tlo lebelela tšona ko guardian fund, and then e le ko guardian fund wena o tlo e kry-a ka kgwedi, and ye e tlo šalang wa kry-a le gore ngwana maybe o thoma o kgona go te support-a before tšhelete e la e šala, then tšhelete e la e tlo tšeiwa back ya boela go papa go bana. Ke a leboga. Thank you very much. I'll pause here.
Thank you, Advocate Palane. At this stage, we're going to take questions. I've got 2 questions. My sister died. Can I apply for maintenance for my niece who is in my care? The other question, I'm a grandmother and my daughter has since died. Can I apply for my granddaughter who's getting a foster care grant? I would like to advocate Malega to assist with these 2 questions.
Thank you. Regarding the first question, where one is asking if they can apply on behalf of their niece, where the mother has passed away. Yes, it is possible as long as you know where the respondent is and you have those details that were mentioned that you need to take along to the court. Because now, if you are the legal guardian of your sister's child, that is your niece, then you are in a legal position to apply on behalf of the minor child so that he or she can be supported from the parent that is still alive.
Okay. For this one who's getting the foster care grant, is it possible?
Okay, I'll start by asking as to how did the child get the foster care grant if one of the parents is still alive? Because the father, if the father is still alive, then the father is the one who's supposed to pay maintenance for this child. But at the same time, I would say I would advise the person to go to court and make an application for maintenance, because it is the responsibility of the father to make sure that the child is being taken care of. Thank you very much.
Okay. The third question, my baby works overseas. Can I still apply? Can you hand over the question to Presiding Officer?
Right, yeah, there is what we call reciprocal enforcement of maintenance. That is now when the respondent is not in South Africa, you can still apply for maintenance. But the best thing is to go to court, because it's not every country that is listed or that has got that agreement with South Africa. So if yes, the respondent is in those countries that we've got the agreement of the reciprocal enforcement of maintenance, it's possible. But I think the best that the caller or the listener can do is to go to the nearest magistrate court and then take it from there.
Okay. My daughter does not want to apply for maintenance against the father of her kids because of intimidation. Can I apply on behalf of my grandkids? Advocate Palane.
Thank you very much. First of all, it will as long as you are staying with the child, you can apply for maintenance on behalf of the child. It's not only the mother who can apply for the maintenance of the child, even the grandmother can apply for the maintenance of the child, as long as she will be able to list the expenses. If she knows the expenses of the child, then she must just go to court and apply for maintenance if her daughter is not in the position to do so.
Thank you. I was married with kids from a previous relationship, but my ex-husband adopted my kids and they have his surname. Can I apply for maintenance even after the marriage ended? I would like the presiding officer, Ms. Wusisiwe, to answer the question.
Yeah, if a person adopts kids, formally adopts kids, that person takes full parental rights and responsibilities in respect of those children. So the fact that the two has divorced does not take away the fact that those children were adopted by the ex-husband. So yes, she can still apply for maintenance from the ex-husband as long as there is an adoption order that was made against him.
The last question, ke dife ditlamorago tsa motho wa go se patele? Meaning, what are the implications of someone refusing to pay after an order has been granted? Can you also tackle that?
Right. Yes, I've explained earlier on that the risk that the respondent is taking is him or her being blacklisted. We all know what blacklisting means. It means that now they will send your names to the credit bureaus to say that this one shouldn't be given credit due to the fact that he's unable to meet his obligation. Because remember, a maintenance, if you don't pay maintenance, it's a debt. So if you don't comply with the debt, the Act allows that if on conviction, if it's proven that you failed and you didn't have any valid reason to do that, then those are the consequences that you can be blacklisted.
Okay. There is another question now. Will you be looking into where the money goes once paid? Will you be monitoring how the applicant spends the money? Will you be monitoring if the applicant is abiding by the initial court order allowing the child to see the paying parent? Will you be looking into false allegations against the applicant? I think Advocate Palana can start it, and then the presiding officer, Ms. Nkosi, will add.
Okay.
Let me repeat again the question. Will you be looking into where the money goes once paid? And then will you be monitoring how the applicant spends the money? Will you be monitoring if the applicant is abiding by the initial court order, allowing the child to see the paying parent? Will you be looking into false allegations against the applicant?
Okay. The first thing is, unfortunately, we are not going to look into what is it that the applicant is spending the money on. But you, as the respondent, you have got the right to check if the money goes to the children as it is supposed to. And if you have got any problem, if you encounter any problem, you see that, you know what, I'm paying 10,000 rand a month, and the applicant indicated that my children are going to school at a private school, but now my children are going to a non-paying school, and my children do not have clothes, and. Then you have got every right to stand up and come to court. And in fact, you have to go to the social workers. That's the first thing that you are supposed to do. You have to go to the social workers and inform them that, you know what, I can see that my children are not being taken care of, and I am paying maintenance on monthly basis. I don't understand where the money is, so that the social worker can go and do a research and check as to what is really happening there. And after checking what is happening, if there is a serious problem, then he must write a report on your behalf, and you can come with that report to our offices so that we can call the applicant and see to it what is it that needs to be done. Because now, sometimes it might be a question of the child now being having special needs, and the child needing to be taken care of, maybe by somebody. The children haven't been to looking into whether the children should be removed from the applicant or not. And as to whether we should look into the respondent, the visitation rights. Unfortunately, when we deal with maintenance cases, we don't deal. Maintenance and visitation rights are totally different, and they are dealt with by different forums. In maintenance offices, we only deal with maintenance. And when you need visitation rights, you have to go to a different forum altogether. Thank you.
Thank you.
I think there is a misconception here to say that if I don't see my children, then I'm not going to maintain them. As it has been alluded earlier on, those are two different aspects. Maintenance of a child, it's a common law obligation or duty that comes with you having brought a child into this world. Whether you see that child or not, it's immaterial to the maintenance of the child. If you've got issues with the visitation or seeing your child, then you go to the children's court and you're gonna say, I've got a problem. The applicant or the mother of my child does not allow me to see my children. Then that court will assist you. But then you cannot withhold maintenance just because you don't see the children. That will be wrong.
Thank you. We've got another question here. After 12 years of them not sorting out my maintenance, suddenly my file paper as well as on the system disappeared. After insisting, the father gets arrested. Numerous successful summons and father was lying about him not working there. 100% someone was paid off, but no one. I think on this question, the listener can assist us because there are lots of things. I can't even read this question. He or she can assist us by sending the question to the communication@npa.gov.za. He can send an email to communication@npa.gov.za. He can also assist us by indicating whether this question is for the province of Limpopo or the other province so that it can be resolved. It will be sent to the seniors. Thank you. We've got the last question. Suppose the person receiving maintenance is misusing the money. How does the court or NPA intervene? Over to you, Advocate Palane.
Thank you. As we have already indicated here, unfortunately, we don't follow the applicants and see what they are doing with the money. Unless if you yourself see that now there is this problem and the applicant is not using the money the way she is supposed to. And let me be clear here. You know, sometimes you find that the applicant, you make an you pay maintenance for the first time, and you start by saying, now I've seen the applicant, she has done her hair, she has bought new hair, she has bought, you know, all those things that you feel that your money is being used for that. But the applicant maybe has been buying those things even before you paying the maintenance. Can we please give it this time and see if our children are really suffering? Because there is one thing to say the applicant is not using the money the way she is supposed to, and one thing if you can see that, but I'm paying maintenance, but my children are suffering. As I've indicated earlier on, if you see that happening, please involve the social workers. They will be in the best position to assist you. They will even write the report for you if you go to them. Thank you very much.
We've received another question. What recourse do I have in case where the court has erroneously given money for future maintenance to the applicant and applicant has squandered same?
Okay, as it was said earlier on, that money is kept further on behalf of the respondent by the guardian fund. It will be given to the child, or the applicant will get it on a monthly basis until the child reaches the stage of majority. But in an instance where the money was squandered and you've got evidence to that effect, I'm of the view that you can institute a civil claim against the applicant, because that will be now the person who has squandered the money and not used the money for the benefit of the child. That is why it is important that the money goes to the guardian fund. It's not given directly to the applicant. So if you have evidence, you can then institute a civil claim against the applicant. Thank you.
We've arrived at the end of our program. We'd like to say thank you to the public. We really appreciate their time. We also want to thank our speakers to take their time in order to teach the public about the maintenance issue. On behalf of the DPP here in Limpopo, we really appreciate your time. I thank you.